Hi, good afternoon, everyone. I'm attorney Jennifer Villani Burton here at Lira Law. Today, I thought we would talk about the K-1 fiance visa, and we're also going to do English today, just to switch it up a little bit. The K-1, also known as the fiance visa, has become really popular, and we get a lot of questions about that. I think partially based on the 90-Day Fiance show, which is very entertaining, right? So I wanted to discuss a little bit who qualifies for the K-1 fiance visa, what is it, what's that process, and also compare it to some of the other immigration processes. Okay, so first of all, the K-1 fiance visa is a way to bring someone to the United States. So that means that is not going to be a process for someone that's already here. We have that question a lot of times if someone is engaged and their fiance is here in the United States. We would not be doing K-1 in that situation. So it's Form I-129F with an USCIS. We prepare and submit that, and that would involve an interview at the consulate for the beneficiary. So what are they looking at? They're evaluating your relationship on the bona fides, very similarly to Form I-130, which is used for spouses. So they want to see, is this a real relationship? Is this just for immigration status? How do we prove that? The same way as we normally do. Photos, communication, if you're sending money to your fiance, things like that. There also is a requirement that you have met your fiance within the past 2 years in person. So that's another thing we address. We also need to have proof of intent to marry. So that is done from each person with a sworn affidavit that you're swearing when you enter the United States, you in fact do want to marry this person and that you're going to do so within 90 days, like the show says. So the first step would be filing that form, getting that approved. Then it's going to get forwarded and go through the NVC, which is the National Visa Center with the consulate. And the interview over there involves the medical exam, the fingerprints, very similar to the spousal-based process abroad. So assuming that goes well, the person is going to be granted that visa, which is going to be placed in their passport, and that is how they're going to enter the United States. Then once they're here, that 90-day clock starts ticking. So then they would be required to marry within 90 days. And at that point, once you're married, we can file the adjustment of status. So that is the green card application. So the fiance visa does not give you permanent residency status here. I think that's a common misconception too. It is just the way to get here to the United States. So if you are in a relationship with someone that's abroad, this is a good option to explore. We will chat with you and your fiance and see if that best fits your situation or kind of what your marriage plans are, where you want to get married, everything like that. That is the fiance visa. That can also, in certain times, include your minor children, your fiance's minor children, your stepchildren. So that's something else to chat about if that is in your situation. What else? If you have done a fiance visa for someone before, so you're the petitioner, we want to chat about that because there can be that can be evaluated if you have filed more than once. If they're considering you a serial filer, we would want to check into that. So that's the fiance visa. When you get here and you file your 485, your adjustment of status, that would be based on your legal entry and approval pursuant to that fiance visa. So you would not be filing a Form I-130. We would not need to file that. It would just be your Form I-485. So you would have an interview here for you and your now spouse, and your counsel can attend that with you. It should be pretty similar to a adjustment of status based on, if you were filing the I-130 together with the I-485. Doesn't really change anything for that. And then most likely Fiance, those who enter as fiance visas, just based on the timing and the needing to file to marry within 90 days of entry, everything like that. A lot of times these people will end up being what's known as a conditional permanent resident. So if you are married less than 2 years at the time of the approval of your residency, you will first have a 2-year temporary green card. So that's happening to a lot of our fiance clients just based on that 90-day requirement and that timeline. To remove the conditions on your 2-year green card, you need to file Form I-751, and that's basically going to be showing you're married, everything is still going well, continuing bona fide proof of your marriage. And you may or may not get an interview for the 751 filing. Normally, you would not if you have sufficient evidence, everything like that, or what happens if you've divorced. There is a way to file Form I-751 based on the fact that you married in good faith, but the marriage is terminated now through divorce or annulment. That can be a little touchier, so you definitely want to speak to an immigration attorney and have your options evaluated for that. Okay. So that's a bit of information about the fiance visa. Thank you for letting me share that with you. If you have any questions about the fiance visa process or any other immigration process, please send it right now. Post your question, and I will try to answer it right now. Okay. So again, I'm Jennifer. I'm one of the attorneys here focusing on the family-based petitions. So if you have any immigration law questions, doesn't have to be fiance visa. Any questions, please send it. And thank you for being here with me and listening today on this Monday. Okay. Okay. So since we're still waiting, we can go ahead and talk about another subject. Something else a lot of questions arise about is, when can I file for citizenship? So this is a good thing to kind of go off of on the 751, the temporary residency. So when can you file for citizenship? Well, the first step is your green card. And that's commonly confused, right? Because a lot of people say, well, I want to get my citizenship. Or people want to get citizenship for someone else, not realizing we have to go through the whole green card process first. So that's kind of a language semantics thing. But once you have been a permanent resident, so does that count if I have my permanent residency with my 2-year card? Does that count towards my citizenship? Yes, the time starts when you are admitted on your 751 card. So that is going to start the clock for applying for citizenship. However, you have to file Form I-751 before you can file Form 400. So what does that mean? If you're still married to your spouse that you got your 751, your temporary residency through, you need to file that form jointly. Okay, so that's going to require signatures from both of you. That's option one. If your spouse has passed, you and your spouse are no longer together, you were the victim of abuse, certain other situations, you still can file that Form I-751 on your own with what's known as a waiver of joint filing. Sometimes, due to the extreme processing times, you would have your interview for Form I-751 and Form N-400 done together. That is something we're seeing at the Dallas field office. So that's something to be aware of. Or let's say you went right off the bat, you got the 10-year green card. The date of admission on that card is going to start the clock for your N-400. So we need to show if you obtained your residency through your marriage to a United States citizen and you are still married to and living with a United States citizen, you have a 3-year filing timeline. So what does that mean? After you have been living with, married to, and admitted as a permanent resident for those 3 years, you can file for your citizenship. There's actually a 3-month early filing requirement. So what does that mean? 2 years, 9 months. Once you meet that condition, you can go ahead and file for your citizenship. And it's also important to note that that is evaluated at the time of filing. So it's not, by the time I have my interview, I'm going to have been a resident 2 year, 9 months, or I'm going to have been living with my spouse that long when I get my interview. No, it's at the time of filing. So that can happen too when you get your interview. If you haven't been a resident for long enough, it's going to be denied. The other option is 5 years. This is the most common, probably that most of you have heard about or are doing. Once you have been admitted as a lawful permanent resident after 4 years, 9 months, so that again is the early filing, the 3 month early filing window, you can go ahead and apply for your citizenship. So who would be eligible to do that? Well, let's say I got my residency through my employer, through my brother or sister, through my lawful permanent resident spouse, through a U visa, through VAWA. VAWA, there would be a little asterisk, but any of those other ways, I'm going to be under the 5 year. Or let's say, well, I got my residency through my marriage to my spouse, but I got my green card 10 years ago and we've been married 12 years now and I never filed for citizenship. Okay, you obviously can do that because you meet the 3 year or you meet the 5 year. That's important to look at too, because if you're doing it through your marriage, you need to send proof of your marriage with your N-400 application. So what does that mean? Well, if I am early filing or I'm filing based on my marriage to my spouse, I need to send proof of my marriage. So I need to send my marriage certificate, taxes, pictures, bills, bank account statements, everything like that. If I am filing on my own through the 5 years, I don't need to send any of that. For your citizenship filing as well, the statutory period is going to be for good moral character. So what does that mean? Well, they are reviewing your background, right, when you apply for citizenship. So they're going to either be looking back 5 or 3 years. So that's important. If you have a conviction and you're eligible more than one way, right, we want to check that out. So that's who can file for citizenship and when you can file for citizenship. Thank you for being here again. Thank you for spending your Monday lunch hour with me. If you have any questions, please send it over. I will do my best to answer right now. And obviously this is a safe space to ask questions. What else? What other questions are we having? With regards to citizenship, since next year is an election year, it's a good time to file. Why is that? Well, to be able to vote, you need to be a citizen. So USCIS is trying to focus on those applications. So they are trying to be speedier in granting the interviews and approving N-400 applications right now so that those people can go ahead and vote in the upcoming elections. So if you've been thinking about it for a while, putting it off, which is, completely normal, if you're eligible, go ahead and file. Or if you want to see, am I eligible? Please call us, make a consult, talk to someone you trust that works in the immigration law field and see if you qualify. Some other things. What does citizenship mean for me and my family? How does that help me? If you have minor children who are permanent residents living with you, this can be a really neat way to make them eligible for citizenship while they're minors. So that's something you want to check out. That's something I have seen clients get excited about that they didn't know about. So if you have minor children who entered as permanent residents, they're living with you, they're in your custody, there might be a way for them to get their citizenship, without having to wait until they're older, without having to take the test, everything like that. So please explore that option with us as well. Again, I'm attorney Jennifer Burton here at Lira Bravo Law, answering your immigration questions today. If you have a question, please send it over. If you have a question about your case, your friend's case, your neighbor's case, what's going on in the news, please send it over and I will do my best to answer it. I did want to speak about the U visa again too, which I know we talk about, but a lot of those have been in Spanish. And obviously, unfortunately, being a crime victim, that can happen to anyone. So I know we have some people that need this information in English or in their native language too, which should be available through USCIS. But what is the U visa? The U visa is for victims of crime. So it was a program passed by Congress to encourage and strengthen the relationship between immigrants and law enforcement. So a lot of times, understandably, people who were crime victims or witnesses did not want to call the police because of fear of their immigration status, fear of their family members' immigration status. So the government did this program. So if you can show you were a victim of a qualifying crime, which typically has to be a crime against you physically, not just your property, and that you cooperated with the police in the investigation. So you made that report, you assisted in a lineup, you were ready to testify if needed. They can sign, certify, which is filling out Form I-918B, Supplement B is what it's called. And once this is signed and filled out, you're going to be eligible to apply for the visa, for the U visa. Not all crimes qualify, and not just any person can sign. So it actually is a pretty, it can be an extended, difficult process to obtain that signature. Legally, every department, so the district attorney, the police department, they are allowed to make their own decisions and have their own policy for when to certify. So what does that mean in practice? It means it can really, really vary. So there are some departments where they do not care how much time has passed since the crime happened. They will sign. Or they do not care that they do not have any leads, or the case was not taken to trial. But there are other departments that do care. Dallas Police Department, for example, you want to make sure, if you were a crime victim in Dallas, you want to make sure you get on top of that as quickly as possible, because they do have time limits for how much time has passed, when they can sign, everything like that. Okay, so please, if you have a question about a U visa certification, any immigration topic, go ahead, put your question in, and I'll try to answer it. Okay, so that is the U visa. Another thing we're always talking about, but that is common, and again, everyone needs information about this, is VAWA. So what is VAWA? Violence Against Women Act. It's important to note men can also be victims. So it's not just for women, even though that's the name of the statute. So if you were abused, that can be emotionally, mentally, by your United States citizen or U.S. lawful permanent resident spouse or parent, or your child. Those are a little more complicated, but if you were validly married, married for good faith, so not just a marriage for your green card, but you were in a real relationship and you were abused, this is an option for you. For this one, it is not required that the government fill out a certification. So it could be you didn't even ever make a police report, although those help. If you have other proof of what you suffered, you could still qualify. So if family members know what was going on, you have photos of things your spouse destroyed around the house, you needed medical attention, you were in therapy, a lot of different ways we could show this situation. And if approved, it's going to give you legal status here, work authorization, and in a lot of cases, a path to your residency. So that's very exciting. Again, if you were ever the victim of abuse from your child, your spouse, please speak with an immigration attorney or an immigration nonprofit to see if you're eligible for this. For parents, for parents who have been abused by their kids, we've been having a lot of questions, and I think there's been a lot of chatter on TikTok and other things about this, but it needs to be an extreme level. So it's not just the normal things us parents deal with, right? It's not my child is back talking, something like that. It's that your child is abusing you. Your child, sometimes that is physical abuse, or that's emotional abuse, verbal abuse. There are other people that know about it, things of that nature. Please speak to an immigration attorney, make a consult with us. We'll go through it with you and see if that's a possibility. Okay. Thank you for being here with me today, Monday afternoon. Again, please send your question. Take advantage of this opportunity. If you have any questions, just send it over and I will do my best to answer it. Okay. Thank you. Okay. So I'm still waiting to see if any questions come through. But in the meantime, what else can we talk about that was not a question, that's going on in immigration law right now? I know last week, Attorney Jenna was speaking about DACA advanced parole. So that is something that has opened a lot of doors for a lot of people. If you have DACA and you want to travel, you need to travel abroad, please contact us. Call us and make a consult, and we can evaluate the possibilities for you. And that's going to open other doors for you in a lot of situations as well in terms of obtaining your permanent residency. So DACA clients, siblings of DACA holders, friends of DACA holders, if that is you, it's a good time to ask about that. So please let us know. So if you had a question about DACA right now, or a question about DACA travel permit, advanced parole, please send your question to that little box. Okay. I've also had a lot of questions recently about expediting. What is an expedite? An expedite is requesting from USCIS that they process your case more quickly than the posted processing time. So it's basically asking if you can jump the line. Typically, that will be approved for two reasons: urgent humanitarian need, normally health, or extreme financial loss. So if you're in one of those situations, if you have a pending petition already filed, let us know. If you're a current client listening to this, let us know, and we'll see if it's a possibility. We can't guarantee the government will approve it. Unfortunately, it is the government's decision, but we can always try. Okay. Again, if you have any current questions, please send your question over, and I will do my best to answer it right now. Okay. If you are wanting to naturalize, if you are wanting to go ahead and file that family-based petition, it is always a good time to check your records too. What does that mean? Well, a lot of us, we have things we don't remember, right? I have clients that they remember very little about certain things. So if you were ever detained at the border, if a petition was filed for you and it's lost, or you can't find your copy, or you don't know what happened to it, I kind of explain it as we want to look in the pool, we want to look in the water before we jump in. So a FOIA is a Freedom of Information Act request that can be done to the National Record Center or USCIS. So asking for a whole copy of your file. That could also be done to Immigration Court, EOIR. That can be filed with ICE, Immigration Customs Enforcement. So if you were ever detained at your workplace or within the United States, Immigration Court, EOIR, Executive Office of Immigration Review. Those are all places we can check with your name, your date of birth, if you have your receipt number, if you have your alien number. Those things make it quicker and really help. The other option is your fingerprints. So what are we checking with your fingerprints? Fingerprints are very helpful in locating criminal records as well as immigration issues. So if, sometimes we have clients, they are certain they were fingerprinted, but they do not know what name they gave immigration. Okay, we'll start with your fingerprints first and see if that comes out. If you know you were arrested, but it was, 30 years ago, you were somewhere else for work, or you were driving, you don't even really know where this happened, you don't have records anymore, we can start with your fingerprints. And that can help us narrow it down and be able to ask for those records and then have them to file with your case or to make decisions about if you qualify for certain benefit. So it's not dangerous to ask for your records. A lot of times people have that question: is this going to affect my case? Is this going to blacklist me in some way? It's not. everything would go with our address. So if you have a criminal conviction or something and you're understandably worried, it would go with our address. All the results would be sent to us. And once we have those, we're going to sit down with you and evaluate your options. So, do I have a conviction that makes me ineligible for my green card, ineligible for my citizenship? Do I have a removal order? Something like that. What took place at the border? Those are all the kinds of things we are happy to investigate for you. It normally takes anywhere from, I would say, a couple months is the average. If we're talking about extremely old records, that can take more time. Also, sometimes clients know they gave another name or date of birth. We would want to put all of those on there to look. Fingerprints, normally a bit quicker. If you were 10 printed, so all 10 of your fingerprints were taken, that is very likely to come up. If you were only your thumbs were fingerprinted, that is not as likely to come up. That was something, more common previous years. But we can still check. Okay, so that is about FOIAs, Freedom of Information Act requests, and fingerprinting to make decisions about your immigration options. Okay. Thank you again. I'm Attorney Jennifer Burton at Lira Bravo Law, here today with you the first day of May on Monday. If you have any questions, we got a couple more minutes, so please send your question over live, and I will do my best to answer your question. Okay, I'm going to wait just a second to see if we get any questions. Okay, if you don't feel comfortable asking your question on here, no problem. Please just call us to make a consult, send us a message. You're going to meet with an attorney. You're going to discuss your case privately, and we're going to tell you what we think. So give you options. If there are no options, be honest with you. Okay. Thank you so much. It's been really great to speak with you guys today about the fiance visa, VAWA, U visas, DACA, citizenship. There's just so much going on and constant changes, right? So I appreciate you looking to us for information about that. Again, I'm Jennifer Burton. If you have a question, running out of time to send your question, so I'm going to wait a second. If you have an immigration question, please send your question and I will do my best to answer it. Okay. Well, thank you so much for being here with me today. I hope you all have a wonderful day, week, and month of May. Okay. Thank you. Take care. Bye-bye.